Gang, gang. Gang, gang. Yeah. Gang, gang, emergency Zoom film at 11. Same 5 goons, same deranged obsession. This changes everything. Bro, it's page 47 of emotion they skin while half watching Yellowstone. Gang, gang, squinting at 8-point font like detectives. Zoom so far and the pixels are screaming for mercy. Look at this, timestamp 20, 22, my God. But they're yelling it like they just cracked Watergate. High five. Mike's been muted for 20 minutes, still barking. Circular logic, so a lot of time to seem impressive. Trust the plan, this is massive. Nah, fam, it's boilerplate and it's mid at best. Gang, gang. Self-appointed outrage squad patting each other like they personally ended corruption. Gang. Dropping bombshell tea that's been sitting in pizza since breakfast. Gang, gang. Moral high ground speed run, they'll flip the script the second it's convenient. Gang. Same PowerPoint presentation, new day, same brain dead narration. Gang, gang. We're not obsessed, we're just passionate. 3-hour living yesterday's hoodie, passion in my ass. Why is he even breathing right now? Says the guy refreshing notifications every 14 seconds. Gang, gang. Playing lawyer on God mode, reading comprehension. Stuck in elementary, confidence in the stratosphere. Case dismissed. They're screaming to the void. Motion still pending, but go off, I guess. Disagree? Obviously a paid shill. Actually read the filing, deep state plan. Laugh at them, you're clearly compromised too. Exist in the same zip code. Suspicious behavior, notify the group chat. Gang, 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 gang. Tighter circle, smaller brain. Gang, gang. Echo chamber finally running out of oxygen. Gang, gang. Yeah. Gang, gang, acting the actual judge like it's group chat. Replay all meltdowns, labeled just asking questions. Got warned by the core once, that was a suggestion. Still yeeted the same screed like it's strictly trash talk. Gang, gang, we're above all this drama. While screenshotting, they on meltdown for content. Preaching peace and love while actively baiting bears. And fake shock when the bear finally bites back. How could this happen? Gang, gang. Synchronized tantrum hours. 5 tabs open, all the same screenshot. Different zoom levels, gang, gang. Premature victory lap over legal language, still can't pause. Gang, gang. Standing 10 toes on business until tomorrow's violence and I'm scrambling again. Gang, gang. Hype the claim to the moon, then ghost the chat when it ages like milk. Gang, gang. Gang, 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 gang. Gang, gang. Refresh, refresh. Gang, gang. Gang, 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 gang. See y'all same time tomorrow. Gang, gang. Don't be late.
Such a good time with Rosalind tonight. We had a blast. It was fun. If you haven't checked that out, go over and check it out. We were talking all about like AI and music, all kinds of crazy stuff. Like, where did I come from? In my mother's womb, as I tell everyone. But no, we had a good time tonight. I'm glad all of you that were able to make it by. We definitely appreciate it. I thank you all. Showing some support to Rosalind. She's good. She's good people. I quite enjoy her. And I know that's hard to believe, but yes. Jeremy exposed a bunch today. Yeah, I did see quite a bit today. It is quite crazy. There is some and I know that Tug is probably reading over something right now, and I may get to some of that, but I've got something else I did want to show you, and I forgot that I never went back to this, and it is Tuesday. Good to see you, Daniel Berry Sports Highlights, the greatest sports highlights. This thing is irritating my ear. It feels like there's suction in there or something. It could just be the weather. I think I'm getting some sinus problems, but we'll see. We'll see how we do. First contempt stuff. Ooh, I hadn't seen that yet. I'll have to see if I can get a hold of that. I'll read over it and we'll see what it is. Inspiration. We'll have to definitely give that a look over, but I think you guys are gonna like this one. This has to do with dues. And it's about 14 pages, but if you saw that I was reading through some of this the other night, what that was Deuce's motion there. And so tonight I think I'll read, this is his filing, his response, Cayo's response to it, and we'll see what exactly he says, because I'm sure that's going to be interesting. And if we have time, I've got something else that I'll show you that we've been following off and on, and I find it interesting to go back to. My volume is a little low. Let me see what we've got going on here. There's a possibility that I can probably bring that up a little bit. Yeah, that should be good. Yeah, that should be a little bit better. I did bring it up. I think I turned it down the other day. So that should be just a little better. Spring in the south, the sun is shining, the birds are singing, all the cars have turned yellow. Exactly, Wes. That is the crazy part of it right there. It has been absolutely some of the crappiest weather. But I was after the stream, I was getting Rosalind to help me out on using Adobe Premiere, because there was a couple of questions that I couldn't figure out. I could do most of what I need to do, but there was a couple of things that I was asking her to show me how, and she was like, well, you do this, and there it is. And I was like, oh man, see, pollen storm. Yeah. It gets crazy here. It's crazy here. So this one right here is coming in from Cayo, and I'll share this. And like I said, if we have time, I've got something else I wanted to share with you guys tonight, in case you hadn't seen it. Greetings from the UK. It's 3:20. Should be asleep. Sleep. How you doing, Levy? Good to see you. Gang in chat. So this I'll just remove from there. It's easier to do it this way. There we go. So defendant's statement of fact in opposition to summary judgment. The defendants object to all hearsay statements offered in the plaintiff's exhibits. On April 9th of 2018, think about this. This has been going on since 2018. Cayo emailed Bruce asking, do you want to get involved in a winnable case of defamation of character against a rich person? See Bruce's affidavit. The case was on behalf of a plaintiff, Stephanie, who was falsely accused of theft by John and criminally prosecuted before the charges were dismissed. Now, he admits to it, but the agreement was modified several times, including but not limited to the following modifications. Deuce resided overseas in Armenia, as was known to Cayo, with whom Matzkin was in periodic contact over the years. And he says he admits that, but Matzkin told me he would be in the U.S. within a year in case there is a trial. Number 3, Cayo did not realize that malicious prosecution would be alleged against a non-police private individuals. And he admits it. However, to determine if you can sue a private individual for a tort like malicious prosecution, all someone has to do is Google something like, can you sue an accuser for malicious prosecution? You would get an answer that says yes. Any non-attorney can ascertain the answer, and so could the defendant. In addition, I have on my computer a copy of the table of contents of a legal encyclopedia called Causes of Action since 2012, which I review when I have questions about claims and statute of limitations. My agreement with Stephanie did not include malicious prosecution. CKO affidavit. Solaro was free to retain another attorney to file even more claims than malicious prosecution. Similarly, Matzkin did not realize he could have requested a double and treble damage pursuit CGS and in the prayer for relief when he filed the amended complaint. On January 4th, Ducey emailed Cayo asking if anything came out of the Solaro matter, which is Stephanie. You want to help? Case is on. He admits. Cayo revealed he was unaware the statute of limitations for malicious prosecution action is 3 years from the date of termination of the underlying criminal proceedings. Well, he admits that. The only statute of limitations I can definitely state what I know is written contract, which is 6 years, and negligence, which is 2 years. All other statute of limitations, I always check and ask if someone asks me. I would not pretend to know or recall out of precaution. I have on my computer a copy of the table of contents, and he basically says the same thing. Same previous citation for J in paragraph 3. My agreement with Stephanie did not include malicious prosecution. Now, Ducey believed that Stephanie had a strong case for malicious prosecution, also believed the case was a strong one for punitive damages. And he denies because the defendant is unable to admit or deny what the plaintiff actually believed in his mind. No one would want to. Oh, thanks for the super tip. Oh my gosh, did someone super tip? Yes, Fallen Hero. The man, the myth, the legend, Shibito. He's given like a little wave. That is very cool. See, it only tells me what you see right there. So that means that you're waving and you're greeting with the little Shiba dog. Thank you so much, Fallen Hero, for the super sticker. That's usually what that means whenever I get something in there that says that. Thank you. Appreciate it. Ambulance chaser. Well, no, in this case, he was approached, and he was asking Bruce if Bruce wanted to be involved in this case, and Bruce agreed. As Matzkin believed Cayo would likely lose the lawsuit on his own because he would be overwhelmed by an aggressive defense counsel because he was incompetent. Now, he denies because the defendant is unable to admit or deny what the plaintiff actually believed in his mind. Cayo filed the lawsuit in June 2018, leaving out malicious prosecution. And that he says he denies malicious prosecution was not one of the claims I was obligated to bring. Matzkin has no agreement between and underlying plaintiff to show otherwise. Cayo offered to split the fee of 50-50 with Deuce if he joined as co-counsel, and Matzkin agreed on the express condition that he would prepare and file an amended complaint with malicious prosecution claim, and it was the explicit understanding that he would handle the pretrial litigation other than live appearances, but would not attend a trial since he lived overseas. He admits the offer, denies the express condition. The agreement was for Matzkin to do half of the work for half of the defendant's fee, but the plaintiff did not keep his end of the bargain, which resulted in a later agreement for a 60-40 split. There was even an offer from plaintiff Deuce to receive zero in order to cover up his unethical actions would not be accepted by the defendant because not filing a grievance for actions of another attorney that is unethical is a grievous offense. Now, Ducey filed his appearance, and he admits to that. Cayo and Ducey agreed to split the Stephanie's fee 50-50, was reconfirmed in email on January 9th. And he admits in 2021, Deuce relocated to Armenia, and from there he continued to handle Stephanie's litigation. He admits the plaintiff relocated to Malden, Massachusetts, and is unable to confirm or denies the date the plaintiff moved to Malden. Ducey and Cayo spoke frequently. It was regularly confirmed by Ducey that he would not be attending the trial but would work remotely throughout. He continued to handle pretrial litigation while Cayo spent little time on the case. Admit that plaintiff defendant spoke frequently, deny that the defendant agreed that the plaintiff would not be attending the trial. In 2022, Ducey and Cayo retained a Connecticut psychologist as an expert witness to support it. He denies this. All parties, including the client, agreed to retain the expert. Cayo affidavit number 14. In 22, Cayo was suspended for 1 month, resulting in Ducey having to take on the responsibility of expert discovery issues that had been Cayo's task, leading to Ducey's annoyance in Cayo, which he expressed on a phone call. He admits the defendant was suspended for 30 days, denied that Ducey had to take on the responsibility of expert discovery. On June 10th, 2022, Ducey emailed Cayo, and Andre, I'm sorry I yelled yesterday, and other times I feel bad when I do, but really, this case is killing me. I agreed to get involved, and I regret it. Once you're reinstated, you need to take charge of this. I may be willing to go to court for trial, depending on how things are at the time. Well, he admits that. Also, 17. In response, Cayo confirmed he would try a case on his own. You have done enough. I can try the case. I will once I get reinstated. He admits, but that it was because of Ducey's threats to drop out because of the refusal of the defendant to settle, and I didn't want Ducey to totally breach. There was never any alteration in the terms of Cayo's and Ducey's agreement, and there was no contractual obligation as a result of Ducey relocating back to the United States. Well, he denies this agreement was modified several times, including but not limited to the following modifications. Before and during the trial, Ducey served as a fully involved, active remote co-counsel, providing assistance like some god. With reference to juror questions submitted, drafting motions, responses to motions, going over witness testimony, preparing evidence, and spending hours on phone calls late into the nights to strategize and help Cayo prepare for the following day. Denies the plaintiff was only involved in jury questionnaire and jury charge. The defendant was the counsel who was up until 4 or 5 in the morning with the client during 2 weeks of the evidence part of the case. Yeah, so he's trying to make himself sound better than he is. Interesting, huh? Isn't it interesting, my Rama? The trial resulting in a verdict in favor of Zalaro on malicious prosecution claim for $9,300, whatever. The amount total award of this certain amount, he said, well, I admit that. Post-trial motion resulted in this amount being reduced to 101. He admits that. Ducey was astounded when he realized from the verdict slip that Cayo had neglected to request a punitive damages jury instruction. Deny. See exhibits A, B, C, D, and E. After the trial, Cayo stopped being attentive to the case while Ducey handled all the post-trial motions and responses to motion. Deny. Straight up denies that. Ducey was able to negotiate a $115 settlement for Zalaro, $1,400 more than a final judgment exchange for not appealing some rulings. Admit, but the settlement was against the client's wish to have a judgment so she could use against the underlying defendant's case against her and then sue for vexatious litigation. The settlement would have resulted in the client not being to use the judgment obtained after the trial. The judgment was worth more than an additional $14,000 with non-disclosure terms. No one was going to engage in an appeal, and the underlying defendant had no basis to file an appeal against the judgment. Rather than enabling Matzkin to complete the settlement, Cayo removed his appearance and rescinded the settlement for $115 so he could himself control any payment and disbursement of judgment proceeds. Well, he admits the defendant removed Ducey, denied that the reason for the removal, the defendant's fees, were protected by his agreement with the underlying defendant regardless of who took control of the case. Settlement was not rescinded by Cayo. Ducey emailed Cayo and copied Zalaro, offering to accept 40% of the legal fees. Zalaro added, Andre, it does seem Bruce has agreed to all you have asked. I desperately want this done and to move on with my life. Cayo responded, Bruce, I'm done with you taking control of a case that is not yours. As you stated, I am filing a grievance on Monday. Response is objection, hearsay. To the part Zalaro added, Andre, it does seem that Bruce has agreed to all you've asked. I desperately want this done and move on with my life. This statement would not be admissible as it is from a third party and a disclosure of attorney-client privilege information. He admits the part where the defendant made statements as they are admission. In response to email, Ducey replied, what does this mean? Taking control of a case that's not yours? And why does it matter at this point? I've told you you can handle it for as long as you simply confirm the appointment. I don't even know what you're threatening a grievance about. What's the claim you're going to make? Why can't you accept yes, yes, yes on everything you've insisted on? Just end this. Cayo wrote back, fuck you, Bruce. He admits he did that. Cayo, having already removed Ducey's appearance, threatened to withdraw from the case, leaving Zalaro with no counsel and filed a motion to withdraw. He attempted to get Zalaro to agree to pay him $7,500 for a separate lawsuit in which Heiko sued her for separate property damage and assault, and he denies this. On February 25th, 2023, Cayo emailed Ducey explicitly acknowledging the prior agreement for Ducey receive 50% of the legal fee, blah, 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 attempting to extort Ducey into reducing his fee to 10% and admits two things Cayo demanded. And it's a long thing. And he says, yeah, I admit that. Because of Cayo's actions, Zalaro lost the $115 settlement and the amount paid was $101 with no appeal filed, no consideration received. $1,450 above the judgment he negotiated for not filing an appeal. He denies See the affidavit. Ducey emailed Cayo on February 27th, 2023, informing him he had told defense counsel he claimed a lien on 1/6 of the judgment proceeds, which Cayo responded, if you put a lien on the case, which is your right, I will definitely file a grievance against you after you said you didn't want anything and send you everything and you will sign it. Be my guest, Bruce. He admits it. Defense counsel paid funds into the court. Court eventually ordered disbursement to Cayo as the only counsel of record. Cayo having removed Ducey's appearance. Admits the part of the court ordered the funds to be dispersed to Cayo. Deny the reason it was dispersed to Cayo. The funds were dispersed to Cayo because the court determined that only Cayo had rights to the funds. In Matzkin's motion to intervene in the case after he refused to file an appearance as he has in the past as co-counsel, the court stated in part indicated below in docket entry 28215 as follows: the second element has not been met. Sounds familiar, doesn't it? I wonder what kind of deal that he tried working out with Stark. Do you think he's going to go and try sue Miss Stark there? You know, Scott Stark's wife. Do you think that's what he's going to do? That you think that's his next plan, is going after her money now? I wonder what deal they had worked out. That I would be interested, because you know he doesn't do anything without a deal of some sort. So I wonder what he went after. The movement's interest must be impaired by disposition of the litigation without the movement's element. This element could not be met. Litigation complete. Blah blah blah. Attorney Ducey has no interest in the completed litigation, so he has no need to be represented adequately. Cayo refused to pay Ducey 50% of the legal fee, 1/3 of 101, 33,708. 50% of that is 16,854, or reimbursement of his pocket costs of despite collecting it from Solaro. Denies. Defendant denies that he owes Ducey the amount he is asking for. Additionally, the defendant has counterclaims against plaintiff for his actions as claimed in his counterclaims and other actions not claimed in this lawsuit, because the defendant believes this honorable court does not have subject matter jurisdiction based on the diversity of citizenship, because the amount in dispute clearly does not meet the threshold of $75,000. So this would never be in this court case had it not reached that $75,000 mark, but that's what he's wanting. Definition: underlying case means the underlying case where the parties were co-counsel. This honorable court does not have subject matter jurisdiction based on the diversity of citizenship, because the amount of dispute clearly does not meet the threshold of $75,000. Plaintiff misrepresented to the court that Cayo was responsible for jury instructions in the underlying case where the parties were co-counsel. The plaintiff was responsible for jury instructions in the underlying case where the parties were co-counsel. Plaintiff was not astounded when he realized from the verdict slip that Cayo had neglected to request a punitive jury instruction. And 5, plaintiff did not want to contribute to the payment of the fee for the expert in the underlying case where the parties were co-counsel. And 6, without the expert in the underlying case, damage of PTSD would not have been established. 7, plaintiff attempted to get Solaro and the plaintiff to settle for $25,000, the underlying case where the parties were co-counsel. Plaintiff attempted to get Solaro and the plaintiffs in the underlying case to settle for $25,000 without Cayo's knowledge. Had the plaintiffs in the underlying case settled for $25,000, Cayo's 1/3 contingency fee would have only been $8,333. Had Cayo given up on the case after pretrial settlement failed and not tried the case, Cayo would have only been the party liable for a grievance. Ducey agreed to receive $0 because of his ethical violations during the period between the verdict and payment to Cayo in underlying case. Plaintiff did not want to try the case because he needs to smoke marijuana every 15 to 30 minutes. Ducey and Cayo had nothing to do in the case during Cayo's suspension in June 22. Cayo assisted Ducey for free when his landlord attempted to evict him after he moved to Malden, Massachusetts, for constantly smoking marijuana and a complaint by another tenant. Imagine that. Did you notice that? Think about that really, really hard. Number 14. Cayo assisted Ducey for free when his landlord attempted to evict him after he moved to Little Malden, Massachusetts for constantly hitting the wacky tobacco in complaint by other tenants. Interesting, isn't it? He also assisted Ducey for free in many CHRO cases for free while he was assisting Cayo in this underlying case. Ducey would also often ask Cayo for legal advice and opinion during their friendship. Wish I knew what was going on. You don't know what's going on? Tug raid? Welcome, Tug Raiders. Oh, coward, fraud, bullshitter, and forgets which case he's doing. Yeah. Yeah, this is a big problem for him. This will be a very big problem. Oh, and a coward, and a fraud, and a bullshitter. Yeah. So he's constantly asking for help. But he gets all angry whenever people like call him out on his bull squeeze. That's never good. You don't want to be that one, Deuce. You really don't want to be that one. Don't be a fool. How are you doing, chat? I thought that was a good warm up to get people's appetite flavored up. Because we're gonna watch a cool video. I have seen this before, but I don't know how many of you have. This is gonna be good. I think you guys are gonna like this. I think you guys are gonna like this. Now, some of you probably are well aware of who this next person is and what this next person is about. And I think you're going to be interested because you may have not seen this part of it before. Or maybe you have. We will find out. Hey, Mr. Coop, how you doing, brother? Venomous Venoms. Well, hey, how are you? I'm good. Just trying to keep up with lots of people's bubbles and sheep, and it's 3 a.m. Oh, don't you worry about it. You can always go back and watch. It's going to be that is a case that Deuce is suing another attorney. That has been going on since 2018. This little spat. I wonder how this is all going to work out for him. It could be interesting to see, is he going to prevail? Will he get his ass handed to him? Guess we'll find out. Hiya. I think it's the reason his partner sued him. Yeah, that is what happened. There was Deuce that sued him, and Cayo is countersued him. Basically, Cayo is saying, "Hey, this has nothing to do with it. Shouldn't even be in this particular courtroom because it never even met the threshold at all. Never did, never could, never should have been brought into this." Badly? Yeah, it'll end up badly. And this next one, it is about a 2-hour video, but we are going to play it a little bit faster. And I'm going to turn on the closed captions so that way you can see it. We're not going to go too much faster, just a little bit. And we'll probably skip over some parts of it. But this is going to be the case that got me interested in this particular one. I think you guys are going to like this. If you haven't seen it, buckle up, Buttercup. This here is Clayton Eckert. And this is one of Laura Owen's attorneys. And this is the one that was insane. Whenever I first saw this, I could not believe the crap that was happening. So he's here trying to get this handled. I want to increase the volume on it just a little bit so that way you'll be able to hear it. And there's no volume right now because it's before the court gets started. And so this attorney, and I'll go back to it right about there. So this attorney right here was the attorney before Gingras. And no, Gwen, in this one, he does not have an attorney. He's doing this all by himself. While in a court battle, what happens? What do you mean? Like if he's the attorney and loses his license while he is in the court, the other side, whatever side he's on, whether he's the plaintiff or the defendant, representing, like, then what would happen is they would get a substitute of counsel. Like if he lost his license right in the middle of practicing, doing a court case, he can always hand those off to another attorney. That's usually how those happen. And it would be no different than like whenever Scott Stark passed. Okay. Whenever Scott Stark passed, he clearly can't practice law anymore. So what happens is usually the client, if once they say, well, you won't have any representation, they'll usually file a motion, or the judge will create a motion. Sometimes the other side will create a motion, say, well, how about we give them 30 days to find new counsel and get that happening. So that way they have representation. It's not the client's fault that they lost their attorney. Now, if he is a plaintiff or a defendant, it won't change the status of anything that's going on in the court case. It's only if he's representing somebody. So I think that, does that make sense? I mean, and it won't be like something that happens right in the middle of a court case, like they come in and arrest him and haul him off or something like that. Usually, whenever those things happen, and they will stop the case and get somebody new to handle it. That helps. Tinny, you must pay the superhero the late fee. Captain Shazzy needs more tidy whities. I'm gonna make you hurt for that, Venom. I wear boxers if I'm wearing any at all. Damn it. Usually with like some hearts on them, lipstick. Just kidding. My wife doesn't need lipstick. Tiny Patchett, good to see you. Oh my, needs new undies. Happy. Yeah, they're crazy. Hey, Tiny Patchett, good to see you. Good to see you. All right, let's get this thing undergoing. Yeah, this attorney here pulled out of this case and actually filed an affidavit because she was clearly lying. And once he found out, he couldn't represent her anymore. Mm-hmm. And this is the one that allowed her to get that protective order. This is where she keeps readjusting her belly bump, her baby bump. And she doesn't realize that she's being recorded. Yeah, Commando. Mm-hmm. She's trying to get it on her stomach and not on her face. It's crazy. Hello, Sylvia.
Hi, Commissioner. We're unable to hear you.
Okay, there we go. Sorry. All right.
Mm-hmm.
I'm Commissioner Joe Kettis. We're here in the matter of Clayton Eckhart. Am I saying that right now? Eckert, sorry, versus Laura Owens. This is UV 20230539552. We'll begin by having everyone state their name. Mr. Eckert, if you can state your name for me.
Clayton Eckert.
Right, counsel?
Yes, Your Honor. Attorney Joshua Lopez representing Laura Owens, who's present via Microsoft Teams.
Thank you, Ms. Owens. If you can state your name for me.
Laura Owens.
Laura
Thank
Owens.
you. We're here today regarding the pre-issuance hearing on a petition for an injunction against harassment that was filed by Mr. Eckhart. And so we have an hour and a half for the hearing. That means each side has about 40 minutes to conduct their case and their testimony. So you do want to make sure you're being conscientious of what you want to present.
Assistant Flockherder. Nah.
We do have a number of exhibits. And so if you would
Yes.
like to use an exhibit or admit
It
an
is.
exhibit, then you do need to lay some, what I'm going to call foundation for that exhibit, which means you need to tell the court what the exhibit is, if there's a specific date and time that relates to that exhibit, how you have knowledge of the exhibit, and how it's relevant to
Hello,
the court.
Elfie.
And then you need to actually move to admit the exhibit. Want to present an exhibit, you have to, once you've laid that foundation, you have to actually move to the court to ask to admit the exhibit. Just because you submitted them doesn't mean they come into evidence unless you move to admit those, okay? And then you'll have the opportunity, so Record, you're going to go first because you're the plaintiff. You'll present your case and your testimony, and then the other side, counsel will have the opportunity to question you.
Man, trying to take my yum bang.
To question them. And
Yup,
at the
bang.
end, everyone will have an opportunity to make a closing argument, okay? The things that people can testify about, you do need to make sure that they are related to something that you have personal knowledge of. So you can't just say, I saw something on the internet, and so now I can testify about it. Okay, it does need to be something that you have some personal knowledge about. And
About? I need that
I know that
uptick.
this case also has a family court matter. This is not the family court case.
Ooh.
This is not the trial on the family court issues. So I need everyone to focus on the issues that we have for this hearing. So we're not deciding pregnancy issues, we're not deciding paternity issues. Those are not the issues that are going to be decided today. So what this court is looking for,
Trying to get your visa approved, and these wolves keep taking my sheep.
there were a series of events that were aimed at a particular person that would cause a reasonable person to be annoyed, alarmed, or harassed, that that person was in fact alarmed, annoyed, or harassed, and that those actions had no legitimate purpose. Those are the findings that the court is looking to make. So, Record, for you, you're trying to show by preponderance of the evidence that that was the case. And then obviously Ms. Owens is going to be trying to show that there is not a basis for the injunction.
Well, and she's been pretty successful, as we've seen. She's been very successful of getting these injunctions against people to not allow them to, go about their lives. That's what she's doing here. Good to see you, Flipper.
Outlined in the petition are the things that can be discussed or addressed. Okay, but as I said, we're not discussing whether or not officially there's a pregnancy or whether or not officially there is a paternity issue. Okay, so we need to make sure that we are.
She's going to keep adjusting that belly
In our case,
or baby bump.
the series of events does need to be more than one, but it can be over any period of time. So those are the things that we're looking for.
You think she's in her casita?
Your Honor, I have a couple questions.
Okay.
Did you want to hear opening statements?
I mean, I would allow people to do an opening if you wanted to, or you can waive openings either way.
Okay. And my other question is that what I believe that Mr. Eggert is going to present are emails regarding alleged harassment in this matter. But the emails, and I know you had indicated that, and I understand this is not the family law, the family court case.
Right.
The emails and the alleged harassment have a lot to do with paternity and things of that matter. So I think that those things are going to come out.
Casita Royale.
Trying to prove paternity and things like that.
Well, she's got the background blurred.
Has to do with that, and so those things will come out.
And she could be in the main house.
They relate to the specific basis for the communication that they can be brought out. I just don't want the parties to think that I'm.
Absolutely true, Roy. My agreement totally with that.
So, do either party wish to make an opening statement?
Hey, Debbie. Debbie Webb.
Or we can just begin with the testimony.
Hello, Debbie Baker.
An opening statement.
Okay, go ahead.
You're going to hear that back in May of 2023, Laura Owens and Clayton Eckert became intimate, which led to my client becoming pregnant with twins. And since May of 2023, Clayton has refused to believe that my client.
Well, and see, this is what the judge said she didn't want to hear about. I've got it turned up louder than I mean, it's at 400%. Why did it turn down again? So crazy. All right.
Became pregnant. He's refused to believe that he's the father of these unborn children, and he has refused to work with my client to create a plan on how and if he wants to be a part of these.
Why is it acting so weird?
Lies. Instead, Clayton turned to the internet. He's turned to his fans. He's turned to his followers, and he's spread rumors and lies about my client. Clayton has insinuated that my client lied about being pregnant. Clayton posted online about legal issues he knew little about regarding my client, Laura Owens, and a legal battle that she was involved with and is still involved with another individual. Clayton has posted about Laura that has led to harassment by his fans and followers. Laura has received harassment.
Let me try something here because it seems to be correct now.
Messages. Laura was asked to kill herself, and Laura has been staying inside to protect herself, which is why she's currently appearing via Microsoft Teams for this.
All right, let me try something because it looks like it keeps turning it down. I want to see if I can't. I'm gonna refresh the page. All right, let me see if that takes care of the issue with it. Sometimes that fixes it. Doggone it. And
my client. Clayton has insinuated that my client lied about being pregnant. Clayton posted online about legal issues he knew little about regarding my client, Laura Owens, and a legal battle that she was involved with and is still involved with another individual.
Yep.
Clayton has posted about Laura that has led to harassment by his fans and followers. Laura has received harassing messages. Laura was asked to kill herself, and Laura has been staying inside to protect herself.
And I've said this before, this has nothing to do. If other people are doing this, first of all, one, she would have to prove, and you know, I'm no attorney, but in my opinion, she would have to prove that he is directing people to do this. One. Two, he is not doing this. This is other people. So how is it him causing this problem that she has created? Because he's just like, she is out here harassing me and constantly emailing me and nobody believes me. Like, I think that this case was one of the biggest cases after Depp that got brought up, because with Depp, you know, before that, if you think about all this, before Depp, it was believe all women no matter what happens. They're absolutely in the right. You have to protect the victim. That's and absolutely, if somebody is telling you, you know, I'm being abused, you should absolutely, you know, take precautions and make sure that that person is safe. But the moment that you find out that it's not true, like Katie bar the door, you need to suck it up and get the hell out of that stuff. False accusers need to be punished. Absolutely. And, you know, we've said this kind of stuff before, that, you know, this being the first major case after Johnny Depp, where the whole Me Too movement was starting to, you know, go down the tubes. And that's, I mean, that is one of the problems with, you know, people like her, is she starts making these false accusations and completely disrupts somebody else's life. You know, we know of somebody else that's making false accusations too, that, you know, has sort of disappeared, haven't they? Weird, isn't it?
So, which is why she's currently appearing via Microsoft Teams for this particular proceeding. And again, this all stems from Mr. Eckerd's post online. All communication from Laura to Clayton during these time periods that Mr. Eckerd put in his petition has been related to Laura's pregnancy with Mr. Eckerd's unborn children.
But she's not pregnant.
It's also been related to what Mr. Eckerd would like to do moving forward.
And see, that's what his posts were. Like, I don't believe that she's pregnant, and if she is, it's not mine because we never had sex. And he stayed that the whole time. There was never any penetration. Also destroys the genuine ones. Absolutely. Oh, yes, Flipper, thanks for being here. And this is the thing that really is the most annoying part of this. Is you're sitting there going, how is he supposed to defend against himself? She's out here accusing him of, being knocked up, by him. And he's like, I never did this, because she's trying to focus it down on her stomach. She wants to get it so that she can show the baby bump. And she's saying that she's fearing for her life to be there in court. Doesn't that sound familiar? Where you have people sitting there saying, I fear for my life. They're going to arrest me. Wah! They're going to arrest me. And the judge even said, that's absurd. Why would I arrest you? You haven't done anything wrong.
With the unborn children, creating a parenting plan. And actually, it's also in regard to potentially him taking down posts, which again led to harassment by his fans and followers. None of the communication that Laura directed.
So wait, let me get this right. Him putting up posts causes harassment. Him taking down posts leads to more harassment. I mean, can you make up your mind? Gestation was all indigestion, acid reflux. Twins, she guessed, were happening for the third, fourth time.
That Clayton.
Yeah.
Was for harassment purposes.
Is BBP pregners too? Might be.
Legitimate purposes, and a reasonable person in those same circumstances would not be seriously alarmed, annoyed, or harassed by that communication. And
yeah, we know what it is.
I'm going to request that the injunction against harassment be dismissed or not issued. Thank you.
So, for testimony purposes, Mr. Eckert, I'm assuming you're going to be testifying, and then Ms. Owens, I'm assuming, is testifying, counsel.
Ms. Owens will be testifying, Your Honor.
Okay, so if I can have you both raise your right hands, you can be sworn in for me.
Promise swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Yes. You? Okay. All right. Mr. Eckert, if you want to go ahead and begin with your presentation of your testimony.
Oh, boy.
Thank you. I think it is important
See, she's getting that belly up there, and then she'll sit down.
The context of that opening statement, it is what he had stated. I do not believe that Laura is pregnant. I know we're not here to discuss that today, but because of the evidence I will present, I will explain why this
it is
receiving unwanted messages for the last 5 months, and I have blocked this individual from all communication, yet they continue to send me messages.
T42.
And I have asked this individual to early on do a paternity test, and she said she would not do it unless I were to date her exclusively. And so then Ms. Owens threatened to go public, which I have submitted that evidence today. But my reasoning for why I doubt her and why I have chosen to cut off all communication is because, if I can submit Exhibit 32.
Damn, he's still good.
And what is Exhibit 32?
So Exhibit 32 is an ultrasound image.
Was
that I was
3 or 4, something like that,
by Laura.
that we know of.
No ultrasound report was provided, and when I asked to speak with a doctor, she would not allow me to talk to that doctor. We also did an early resolution conference. It was in the last couple weeks. The mediator asked for her to make that phone call to that facility to prove that she and Dave had to do this ultrasound. She did not do it. She was not willing to make that phone call. And so with that
right there, I mean, and make Arizona men safe, keep Laura Owens in prison until after menopause. No, I don't think that'll work either. I don't think that'll work either. I mean, I mean, she'll come up with another thing. I mean, this is crazy. Because I mean, and I didn't, I've gone back to watch this. So you're joining me in for the second one. This is absolutely insane to me that he's sitting there saying, "Hey, we were here trying to get a resolution before this hearing, and part of that resolution was." In proving that, what he's saying is correct, get that person on the phone. And she refused to do this. She refused to get this person on the phone that she's claiming can verify that she's even pregnant. And that right there would be big sign should be a big sign to this judge that she is doing everything she can to harass him.
Picture and that picture alone, I believe it is photoshopped, and there is no report that she has been able to provide. And I've asked for it, and I would like a doctor to be able to stand behind that image, as I believe it's a fraudulent medical record that she has submitted to me via email.
Yep.
Okay.
Okay.
We're moving to admit to the 32.
I would like to admit, yes, Exhibit 32.
Any objection?
Yes, Your Honor. If I'm not mistaken, Exhibit 32, double check.
Fiverr, yeah. But that didn't come out until later. No one knew that it was Fiverr. And when they told her to 86 the pregnancy, she wanted them to sign a boyfriend dating contract. Yeah.
You know what? Actually, Your Honor, I'm not going to object to this.
All right, 32 will be admitted.
Thank you.
Well, and he initially did this without an attorney.
I would also like.
I mean, imagine he is in here going through this, and maybe he just could not afford an attorney at the time. Was like, I'll go in there because I'm telling the truth. Everything that I'm saying is she's batty here, and she's screwing me over. And I don't want to be any part of this.
To admit Exhibit 36, the flash drive.
Before we get too much further, if you can just explain to me what you believe your relationship is or was with Miss Owens, because part of the reason it's an injunction is because of the relationship nature of it. I think that you listed as being not an intimate relationship. So I guess maybe if you can clarify that for me.
Yes.
Well, and this right, and the judge is good for getting off the baby stuff. Watching Megan and Dave Neal the day they found Fiverr, that was something. Yeah, I was there also, Inspector. Yeah, most definitely. That's when that he comes across well. Yeah, I mean, it was amazing whenever I saw this, because I was like, that he's sitting there, fighting all of this stuff, thinking, if I come in, tell them everything going on, they'll be fine. They'll move on with it, and there won't be any issues here. And that's not what happened. It just.
Your Honor, Laura and I had.
But good for her bringing it back.
And oral sex one time, and to me, as I filed this, I did not believe that constituted a relationship of any kind, as it was a one-time thing.
Okay, thank you. All right, go ahead, sorry.
Exhibit 36, I would like to admit that as well. This is a flash drive file. This was also sent to me by Laura Owens via email. She, in this email, which I actually have, can I submit multiples at one time or no? Or reference them at least for now?
Okay.
So Exhibit 18 is a screenshot of the email that she had sent me with this ultrasound video. that she claimed was
Here she
on
goes,
there. I'm gonna
rubbing that belly.
that real ultrasound video. She's claiming that that was the ultrasound of our children. But then I uncovered the Exhibit 34. This is a YouTube video from over 6 years ago, and that video has the video that she sent me within it. And so Exhibit 36 is the video that she sent me, and then the video on YouTube. And as you play both of them out, you can see that they are identical videos. She had cut a portion from the YouTube video and claimed it to be her own when it was somebody else's. And so I would like to, I'd like to admit at least Exhibit 36, but also 34 and 18 to prove that she did in fact send this to me via email, and as 18 and 34 show, but also then to admit 36 because that is the visual proof that these videos are identical.
Any objection to 18?
Yes, Your Honor. I don't think there's enough foundation for the different things that Mr. Eckert is stating. It sounds like something was sent to him, and I don't know what websites that he's going to get these. And the things that he's claiming in here, he's saying that these are identical. I don't know if he can testify that these are in fact identical.
Okay. So 18 appears to be kind of a shot of almost similar to 32, but I think it's closer to matches the 34. But I think
Lift my shirt.
That is correct.
So do you have a specific objection to 18?
No.
Or objection?
If that's what was
I think
sent
one more
to him.
related.
Oh,
Yeah.
wait, 17, 18.
18, I think, was the one that was sent to him. So do you have something specific about that exhibit?
Well, yeah, absolutely. The lab results would have put an end to all of this. But see, that was the thing. She wouldn't turn any of this stuff over, and she never went and had any lab work done. See, this is where it became a big problem. Welcome, Tug Raiders. Waving a roll of quarters. What are you going to put the quarters? You just want the quarters to pull my underpants down. Shame on you. Shame on you, Venom. No, all of that would have taken care of the problem that they were having with this. But she refused. She refused to even turn over any information of where she was supposedly had this. She's claiming that she had an abortion. She's claiming that she had, miscarriage. She's claiming, I mean, it's just like the amount of lies that keep coming in. It's just like, I mean, your head starts to spin whenever you realize that every time that they're trying to like nail something down on it, the story changes. And that is a perfect example. Look at the way that the fleas do their crap. And the whole little anti what the hell's ecosystem. They'll tell a lie, and then they'll double down on it, and then they will get a lot of people going, yeah, totally, that's exactly what happened, and then they'll change it. Perfect example, how much money they were raising whenever they were raising money. Emma Washington, thank you so much. The amount of money that they were raising for a fence all of a sudden changed. I mean, 1 minute it's like, oh, we're doing this using gift cards, and then all of a sudden we need more money for this because the gift cards weren't enough to cover it, and then that changes to well, we've got a full privacy fence to, well, we were out here, we got all of these things put in, we built this fence, and look at how great it looks. To 2 years later, the whole fence is rotting away and just busted and falling apart. Wouldn't surprise me if none of the posts are sitting where they should be. I mean, it's just an absolute, mess. It went from being like, oh, we're going to do all this great stuff to like, yeah, we basically got the cheapest material. And then, it's just going to crap from there. It went from low. We're raising all this money for a barn. And then all of a sudden it changes that, oh no, we're actually raising money for the flea. So that way she can do with whatever she wants to with the money. It's her discretion of what she's going to spend it on, how she's going to spend it. It went from, oh, we're getting this memorial to, well, it's on a boat. Well, it hasn't been built to, well, we've got it. We can't show it to you. We haven't even gotten it yet. I mean, every single step along the way, they keep getting called out on their bullshit. And, they keep wanting to, double down on the same crazy. Oh, does Tizzy have a new video? Was it released today or is it what? Hey, Tizzy, when did you release the video? Because I'll show it. I just don't want to like, I want people to go view it. If you've got something up there, Tizzy, we were talking about you today. You know that we were talking about you. It's weird. Yeah, Tizzy has a new video. It's too long. I've never heard that complaint ever, Tizzy. I've never heard that complaint. It's 30 minutes. Ooh, I bet it's good then. Can't wait to see it. I'll have to check it out. And if you put it out today, then I won't show it today. You guys go check out. It's about 40 minutes, but it's really good. She says it's 30 minutes. That's it. Watch the Tizzy video. It was very good. Awesome. She's going to make the money from my green card. That's awesome. Oh, thank you, Debbie Baker. She is gifted 5 memberships. Do you know what that means? That means that Debbie Baker is wanting to hear that song. She can't help it. It is such an addictive song that I think everybody likes it. So let's give it to you.
Welcome to the shit show.
Yes, every single day. A new flavor of fuckery, cause everybody sucks, you see, and they're dumber than a bag of rocks. Monday, Tuesday, Wednesday, and then 4 more days of increasingly stupid, ridiculous, ignorant, balderdash, poppycock, bollocks, and fuckery. Ah, yes. Welcome, new members. Thank you. Wicked Wench. I am Powell, or Ian Powell. Sorry about that. SF. Yes, I think I got that right. Derek Bass. Kathy Widner. Good to see you. Welcome. Tizzy, great job. I know Tizzy has been on top of it, getting those wonderful things out there. And we definitely appreciate you. And also, thank you very much, Debbie Baker. And I hope you're feeling much better. And congratulations, all new members. Love it.
I mean, maybe
She's
just
thinking.
some foundation regarding who it was sent from and how he knows. Got it.
Absolutely.
So, Mr. Ford, if you can just outline for the court specifically the way that you received this.
Yes, I was sent this by Laura Owens. As you can see in the screenshot, this was sent from her.
What date?
The date of it was October 6th at 4:39 p.m.
Any objection to 18?
There you are.
Or 18 will be admitted. And then 34, give me more information about when and where you received this document.
So, Exhibit 34,
Here she is, rubbing the belly.
As validity at me.
And you notice where she's standing. So if and I'm pretty good on female anatomy, so I'm imagining, we got boob here. You got the boob here. Well, I'm sorry. That's being too gracious. Let me be a little more plain. Okay, she's got boob there. Okay. So what she's doing is she's rubbing this part of her belly right through here. That seems a little high. I mean, maybe I'm wrong, and have been sort of going about this wrong. But I would think that if and like I said, we'll pull this up there. So if her belly is here, the top of her belly, and she's not very endowed, I guess is the best way to put it. Her being pregnant would have to put her boobs like up here. That's what I'm thinking. Maybe she thinks she's a genie. Maybe. Definitely. It's a boy. Baby. I don't know. You ladies that have been pregnant could probably tell me. It's always above the rib cage. What's she talking about? That's what I'm saying. So the baby bump is always above the rib cage. Is that true? I'm pretty sure that I'm not that stupid. She's a bit off anatomically, considering how far along she was supposed to be. Well, that's true. That's true. I mean, they could be up here. That's just a possibility, because she could be completely anatomically incorrect. It might be, maybe. I mean, they're definitely not over here. If they're not over there, then and she doesn't have 3, so there's that. So bad. Tinsel Pepe has become a new member. Miss Peanut has also become a new member. And Rebecca Burns, Lindsay, and Mary Ann, and of course, most importantly, don't ever forget, Tizzy, thank you so much. And
welcome to the shit show.
Yes, every single day. A new flavor of fuckery, cause everybody sucks, you see, and they're dumber than a bag of rocks. Monday, Tuesday, Wednesday, and 4 more days of increasingly stupid, ridiculous, ignorant, balder, dash, poppycock, bollocks, and buggery. She said she has a bun in the oven, but never said it's cinnamon flavored. Support the Tiny Whitey Fund. Oh, you're so bad. You're so bad. You're so bad, Venom. You are going to keep harassing me with that. I'm gonna start using that picture as an avatar.
Not believe that it was in her ultrasound. So I started to look online, and
wait until you see her adjust it up.
Video, and upon playing it, I found that the video that she had sent to me is within that YouTube video.
Okay. Sections to 34.
There you are.
34 will be admitted. And then
and how far along is she? Yeah, she's close to delivery. Well, that's the thing, is at this point in time, she supposedly was not pregnant. I'm thinking that's right. So you guys could correct me if I'm wrong. This was, Yeah, she was supposedly, this is November. She wasn't pregnant. Yeah, that's what I was thinking. Why am I getting dating site ads? Because you keep putting yourself out there. That's why, Venom. I told you. You're gonna make your man jealous. He ain't gonna put up with that. Yeah, I'm pretty sure that this is November, and she is not pregnant. Let's see, the time is 7/9/2025. I think that's the timer. I don't think that's the date.
The 36 will be admitted.
This is October 24th, 2023. So this is October of 2023. She was over 3 months, but yet no certificate of death for the twins she absorbed. Yeah, or any of it. She just kept changing how far along she was. Yeah, this is in October of 24th, 2023.
Yes, I would like to.
Yeah, the adjusting the belly
I would
was.
also like to discuss Exhibit 30. So Exhibit 30 entails a prior court case with this individual. And the reason why I bring it up is because of the repeated or similar patterns of behavior that Ms. Owens has exhibited. In this exhibit, there is an ultrasound in which she presented to this individual, and then it was found that through a reverse Google image search that she had taken that from online as well. In this case as well, she states that she became pregnant by this individual, and she also claims that she became pregnant with twins after one sexual encounter. And so the parallels between my case and this individual's case, I think is important to bring that to light and admit that as well, because this individual has displayed repeated patterns of behavior. And I think that's important to note as to why I question the validity of this individual's claims.
And where did you obtain this document?
I obtained this document from this court. I came in here, it's publicly accessible. So I came here and I searched it, and there's about 14 pages in this that I printed off. There's more in the court system, but I consolidated it to bring out the documents that referenced similar instances. And so
wow. And see, I forgot about that. That he actually went to the court whenever he found out that, something just isn't, something's hinky in this. I want to see if she's ever done this crap before. So he actually goes to this court and finds any information on her, whether this has happened before. And sure as shit, there it is. Like, who would have thought to do that? I mean, that's not something that, most people would do right off the bat. Be like, hey, I want to see if there's anything on this person. And then you go and you put it into their system and you find, holy crap, they have done this before. Like, wow. You've got to be kidding me, chick.
This individual that she had brought this claim against also questioned if she was pregnant or not. It does state in here that she provided sonographic images, and then a reverse Google image search revealed the images were identical to a sonogram found on a blog post from 2015. And then within this document, it shows the pictures that were submitted to the court, the ultrasound in question. And then I'd also like to bring to, in this document, in the picture, it says,
they were entered into court on, and I think I actually have those documents. Those, I'll play it and I'll see if I can pull those up.
That she'd sent to him. It looks like you're going to be a dad to 1 or 2 babies. And so she again states that she was pregnant with twins with this individual. And then on one of the last pages of this document that I had pulled out, it was noted in this court case, the plaintiff reportedly fabricated a pregnancy and subsequent abortion in the past during a relationship with a Michael Maricini in 2016. I do not know, the specifics of all of these cases, but I do want to bring this to light and submit it admit the exhibit because of the repeated patterns of behavior that I think are important to note, because contextually speaking, that is part of the reason why I will then present my evidence towards why I feel I'm harassed, because I do not believe what this individual is stating. I don't believe anything that she's saying, and these are the reasons why.
Your Honor, I'm going to object to this being entered. This is an ongoing case. We don't know what claims are or are not true within this exhibit. I don't think that it's appropriate, and I don't think that it's relevant to Mr. Eckert's petition in this specific matter.
So one of the allegations is a pattern of behavior of accusing men of getting pregnant in his petition. So I guess that's what he's presenting it for. So hang on, Ms. Owens, just a minute.
I think I have
I
elsewhere.
think that's one of the allegations in his petition, but
Yeah.
Again, Your Honor, this is an ongoing case. We don't know what the result of this specific case regarding this exhibit is. We don't know anything about this case. We have it looks like this is some sort of complaint. It looks like it's a motion to dismiss. I'm sorry.
Yeah.
Or there's several documents here. I don't think that this is relevant for this particular case.
It is.
I think that this is speculation. These are claims that other people have made. I think this is hearsay. I don't think it's admissible for this type of hearing.
It was.
so I'm not going to be able to admit Exhibit 30. I do agree that there's not, this is a complaint and a motion to dismiss, but whether or not there's significant information enough to be able to support that and whether you have any knowledge of it is I think I'm not going to be able to admit that exhibit. Ms. Owens is raising her hand, but your attorney is here. So did you have a question?
No, he covered everything.
Okay. And he's going to be speaking on your behalf unless you're testifying. So
I would like to testify.
You have your chance to testify, but you can't testify in the middle of his testimony, and then your attorney needs to be the one that speaks on your behalf unless it's your testimony, okay?
Okay.
All right, Mr. Eckert, anything else?
Yes. Now I'd like to go in and admit each of these documents, and I have them set in an order. So the very first one, Exhibit 1, this is just showing all of the files that I have accrued. There's often 2 to 3 emails that she sends me a day. She started sending me emails, harassing emails on the 6th of June, and she is still sending me emails as of yesterday.
Jeez.
So Exhibit 1 is just showing the frequency of her harassment from a bird's eye view.
And so when you get the email from her, tell me how this gets created.
Yes.
Well, she keeps sending him damn emails. I mean, what the hell, man? What? Imagine how the court's going to feel when they read what mommy told the puppo in what she called an off-the-record chat. Yeah.
So when she sends me emails, I screenshot them and then I place them into these files so that I have them for a record.
Okay. Any objection to Exhibit 1?
Yeah, from what I remember is the ultrasound, the whenever the feds looked into this, the feds, because she's in a federal case, whenever they looked into this, the investigators found that the pictures are the same pictures as her. Well, in one of them, not all of them, because she used different ones. One of them she pulled off the internet. Another one that she used in court was of her sister's twins that she had she had changed the document from being her sister's name to her name. Yeah.
Yes, Your Honor. Again, I don't think that the frequency of emails is
Yes, it is.
something that would indicate harassment without something more. If there's communication back and forth between emails, then the frequency of it, of how many times somebody sends an email, I might send 60 a day, but the frequency of emails between...
Wait, so you might be sending 60 a day? Like, that makes no sense, dude. To the same person? Like, begging and crying and whimpering and telling that you're going to do horrible things? No. Judge should allow these in and say, well, what is the veracity of these emails? I keep telling her, go away, leave me alone. And she keeps harassing me. I keep telling her, go away, leave me alone. She keeps harassing me. We'll take care of this in court. Leave me alone. Who says there's a return response? Yeah, if I get 60 emails from the same person, I'm calling the FBI.
I believe May to now, and I don't know how many these are. We don't see the emails in here. There's nothing to say that this, in fact, is harassment within the meaning of the statute.
Well, let's see what the emails are.
To this being admitted.
All right. Over the objection, I'll admit Exhibit 1.
Nice.
Thank you. Can I continue? Exhibit 2, a lot of these next exhibits are all going to be phone numbers that Laura has contacted me from. She has contacted me from 13 different phone numbers.
Wow.
I finally stopped blocking the 13th one because I knew that she just would continue to create a Google Voice phone number. And so this first one, it says in the text message, it's Laura, please unblock my, and then she shows the number that
she did.
Original number.
Damn.
And so I would like
No, Irene.
one to show again the many different times that she has continually contacted me after blocking her from different phone numbers.
Ooh.
So this is a text message from when? Do you know?
Unfortunately, I don't. It just says text message from today. Again, I was screenshotting these as I received them. I received these over the last 5 months. As far as what exact day, I'm not right now. I'm not aware, and I don't know if there's.
Can you approximate when this message came in, or you don't know?
To be honest with you, Your Honor, as far as when this one came in versus the other ones, I don't know. This one says, I have it down here as her blocked cell number 12, so this is probably one of her last ones that she had sent to me. And I would say that I think this one came through probably about a month ago, because since then she resorted back to sending me emails because she put a mail tracker on the messages. So she was able to see when I was reading them. But during this period of time, when she was sending these text messages, I was not opening her messages. And so she knew through her mail tracker that I wasn't reading them. So she decided to go about the Google Voice manner in order to get them to me, because she could see that I was not opening her emails.
Okay. So you have this one, you believe is from one of the 12, at least one, the 12th message, that as well cell phone number that she was using.
Correct, yes. Each of these came from Laura, yes.
Okay. Any objection to 2?
Yes, Your Honor. Again, Mr. Eckert must show that there is harassment. When I look at this,
that's what he's showing.
Anything that is even remotely close to harassing here. It's a text message indicating to him that they're having a boy and girl. She has an ultrasound to show. I just don't see anything in here that is even related to the petition itself that shows.
Yes, it does. It's going to show it's harassment.
This is simply a text message.
Oh, your belly moved down. You need to push it back up, Laura.
Petition is the high volume of those, and that ultimately he can testify whether he was annoyed or harassed by these. So I'm going to admit Exhibit 2 over the objection.
Thank you. Again, Exhibit 3, just to make this, again, I want to be respectful of everyone's time here. This is, again, another cell phone that she had contacted me from, so I'd like to admit this one as well for the same reasons as Exhibit 2.
Martin,
Your Honor,
and
it
it's in the
sounds like there's
totality.
a number of different,
The totality.
cell phone screenshots submitted to the court, and I just want to make record straight that I am objecting to all of these based on the same reasons I was objecting.
See the beige sleeves on the dress? It's the sleeves of the fake belly.
Okay.
I don't have to just repeat myself over and over again.
All right.
No, I don't think that's what it is.
Record, this Exhibit 3 it has that similar language, the police and block the original number. So you're telling me this came from Laura, but from another block number.
Correct.
All right, I'll admit 3 over the objection.
Thank you.
Mm-hmm.
4, also sent from Laura. This one says that she couldn't get into Google Voice, had to make a new number. So again, this one just
I
shows
lost
that
those captions.
back to using Google Voice and creating more and more numbers.
That's why it's moving so slow.
And yes, I did feel harassed because I did not want these messages. This one you can see I did respond to, and what I said is how I felt. I was asking for her to schedule the paternity test, which she continuously declined unless I were to date her exclusively. But for the purposes of this text message, it was another unwanted text message that she had sent my way.
Mm-hmm.
Tell me a little bit more about the dating thing, what you're telling me when you say that.
Yes, so you can see this in this exhibit
Yes,
here.
you can find the belly
I
online.
won't read this, but I made you a pretty good offer. Meet up tonight to discuss the pregnancy and the possibility.
Oh, yes, it is. You can find the belly online. Okay.
Test with Rabgen tomorrow. So her stipulation for taking a paternity test early on has always been that she would only do the test if I were to date her exclusively for 2 weeks. Then she dropped it to a week. I did not agree to any of that. I simply just said, as it says in here, drop the dating stipulation, schedule the test, pay for the first part of it, then email me when you schedule it, and I will schedule my part. So I had continuously tried to figure this out, and she would not do the prenatal paternity test unless I were to date her.
Yeah.
And this Rabgen is the...
Rabgen is it is the facility that provided the test so that you can test for a prenatal paternity test for twins.
Okay.
Prenuptiary
4 over the objection.
test for twins.
5, again, is another text message from her again, saying that she doesn't know how to use this app. She's referencing Google Voice. She said, I'd like to meet, no strings attached. I did not want to meet with her. She's asked me to do multiple times. I did not feel safe meeting with her because I'm not sure what she would claim if we were to meet up. I don't have a reason to meet up with her. So
that's right.
This is another text message that she sent me that was unwanted and very harassing.
Over the objection, I'll admit 5.
6, again, another text message says she changed her number. I would like to admit this one as well for the same reasons as the previous messages.
She's doing a bad job with her belly.
Number than previously used.
Yes, and then in this one, I would even just like to highlight. She said she threatened to leak this to the media, which I will be admitting.
That's crazy, CJ.
Threatened to go to the media, which she ended up doing. This text message just proves that she was again looking to defame me through basically whether we date or leak this to the media.
About $30.
She threatened.
Actual rumor. That's awesome.
She threatened me.
All right. I'll admit 6 over the objection.
7,
Crazy.
Similar thing again. She stated the time she would do it with no strings attached. I had then responded by saying, let's schedule the paternity test regardless. But she was asking for this agreement and that we need.
Oh, and if you haven't, reach down there and hit that thumbs up. If you like this stream and you want to take that extra step, you're always welcome to, throw a little bit of extra bones this way. We always appreciate them. Not necessary. Just a thumbs up is perfect. And if you want to take an even extra step further, you can become a member. We have gotten, 10 members tonight. And I appreciate every single one of you. You know what I should do is I saw someone else doing this, and I probably should do the same thing is get the little banner set up there that says how many of you have become members. And so far we got 10 members. There we go 10 members, just like that. And then I can put it like that, scrolling, and we will do it like that. And then let's see if it does it. Yeah, see, it does. It does actually work. Ooh, 10 new members. 10 wonderful new members. I love it. And then I can take the chat box and I can move that right up here. And that way you can see the scroll and the chat at the same time. That's pretty cool. See, I like it. Oh, that needs to be a little bit more forward. Let's see. We'll put it right there, like that. There we go. Hit that thumbs up. Yes. See how that works? So we've gotten 10 new members, and we've gotten, what I think, like 3-4 super chats tonight. I have to double check because you guys are awesome. And yep, 1, 2, 3, 4, 5, and 1. I came in, gave super chat, and also got a 1 from Fallen Hero. So yeah, we can change that pretty easy. Like I can let's see, edit. Yeah. See, while it's doing that, then I can do this number and I can put in 2 super chats like that. And then oops, hit the wrong key. I thought I was hitting the forward key and it ended up saying 20. No, now it's asking a question mark. Here we go. 2 upper chats. Well, no, we're not upper chats. There we go. See, it's just like that. And I can also do this. It also really is really cool because I can do this one and then do this and then hit, and then if I change it there and hit paste and then hit save, then it does it like that. Ooh, I like this. I like this. This is pretty cool. Yeah. For whatever reason, it moved the chat box again. I thought it was on top. Okay. It's still not on top. Why is it doing that? Here, I'll just move that down. So that way it works like it's supposed to. Doggone it. Marama, you're cheating. Valor News Parody is celebrating 13 months of memberships. They're giving me credit even when I went AWOL. No, that's because you were gifted a membership. Yeah, they were gifted a membership. That's how it works. Whenever you're gifted a membership, boom, it shows up just like that. I think she's just putting the scrolling text on the bottom. Can you see it? I hope you guys can see it. I think you can. Pilots made in uniforms. Getting ads for investments in prison. Oh, I thought it said prison sex. I was like, what? Investments in prison violence. It's awesome. That's awesome. You guys are killing me.
To meet up for a good faith consultation. Again, I did not feel safe meeting up with her one-on-one, so I disagreed with this. So this is another text message that she decided to send from a different number. These are all, as I can just a reference. These are every single one of these.
Bought it the other day.
Numbers, so these are all coming from a different number.
Yeah. Thank you, Valor.
7 over the objection.
Ooh. And Noreen. Noreen is asking for the song. She wants it. Noreen, thank you so much. Oof.
Welcome to the shit show.
Yes, it is. Thank you for the 5 beautiful gifted memberships. And then also, Jace got 1. Cheat and Vince got 1. Nice. Kim Enright. And Crisscross. Wolf Kender received 1 also. Yes. I love it. I love it whenever that happens. It is so awesome. It makes me excited. Why is it not working? Ah, that's why, because I didn't change it. And then what we do is we put it in there. 15 new members tonight. I love it. We're doing it by the fives. I love it. There we go. Nice. I like how that did it not update. It did not update. Doc on it. I didn't hit save because I'm bad. So bad. And then save. There we go. Now it's showing it. And 2 super chats. You guys awesome. Awesome. Thank you. YouTube has you lumped into some group that can't receive gifts. Yeah, if it's a branded account, you can't receive gifts. That's what'll happen. Why doesn't the judge make her sit down and show full face instead of torso? It's aggravating. I'm sure the judge feels like a fool now after the fact. No, this judge, I don't think this judge even cares. She's just doing her job with the information that she had at that point in time. You want the song again? I mean, I'll give it to you. Big up. Yes, hey, Chief. And Chief is saying, thank you very much for that, Doreen. You got him a gifted membership. That makes him very happy. Yeah, love those memberships.
Send an email to Rabjen, and then she threatened, you want me to go to the public instead of meet up? So those were the options.
Yeah, that's a threat.
With the information.
I'll admit 8 over the objection.
9, another message that I didn't block. As you can see, she sent multiple messages before I decided to block her, and she was asking for a good faith consultation. Again, she was trying to meet up with me. For what reason, I can only speculate, but I did not feel comfortable doing so. And so this is another phone number that I ended up blocking.
And can you elaborate on what it says? I just made what I think is a very enticing offer. What that means?
So to be honest with you, I don't remember exactly what her offer was. She made multiple ones, but they all centered around a very similar, if we meet up and we tried to date, it was 2 weeks, and it became 1 week, then it became just meet up for this tonight, this good faith consultation, and she would make a lot of promises as far as once we do this, then I will go take the test. But again, I did not feel safe being with her one-on-one. I did ask actually to meet up with in the courts, or I said,
smart. I mean, this is smart. I'm impressed that he was smart enough to say that. To say, hey, I don't want to be alone with this person because right now she's accusing me of X, Y, and Z. And if there's any chance that we're alone, there's a possibility that she could escalate it even further and accuse me of something even more heinous, and if she can't have me in any sort of context in any way, then it takes away her ability to falsely accuse me of some other crap. I'm impressed. Like that is one of the smartest things that he's doing. This is why they said they should be required to appear in person. No Zoom, as it would have been obvious that she was faking it. Well, absolutely. But see, one of her excuses for it of not showing up in person, well, because 1, she had an attorney there. 2 is she was claiming that she was so scared that she couldn't be there because afraid of what he would do to her. And which makes no sense, because if she keeps sending these emails saying we need to meet up, as early as, before this court case, that means that she's not scared. But of course they don't understand it. Oh, if this is your second account, Valor News, it's probably branded. Yeah, what the fuck? Is branded a circle with a badger or what? No. I still don't know what a branded account is, though. A branded account is it's something that happens whenever you create sometimes a second account, and sometimes it's because I think MG has that same problem, and it's tied to the same email address. I think that's how it works. Like, perfect example is I have Shizzy Westnut, which is this channel, And then I have Shizzy Wiznut Gaming, and I think Shizzy Wiznut Gaming is actually a branded channel, so it can't receive memberships, which works out really good in a sense, because that keeps from giving memberships to people that wouldn't be supporting your channel or something like that. Because I mean that channel is basically like just a secondary channel. It's a private email address that's more secure. I don't know. I don't know about that. No, because MG has his tied to, whatever email he has on there, and his is a branded account. So there's a way of getting a branded account. Like I had the option whenever I first set up this account, if I wanted this account branded, and I told him no. I didn't want this account branded, and I'm glad I didn't. Now I was like, I don't know. My first YouTube channel was tied to your Gmail account, which was your photography account. My second channel is personal, Gmail, no business name, and it's not branded. Well, I don't know. It's personal, Gmail, no business name. Well, that's because they're two different. Yeah, your second channel is personal Gmail. Yeah, it's a personal Gmail. See, it has two different email accounts. Like Shizzy Wiznut Gaming and Shizzy Wiznut are basically the same channel. I mean, it goes to the same email address. It keeps people from tracking you and keeps you a little bit more private. It's like VPN for emails. No, I'm talking about not your Gmail account. I'm talking about the actual YouTube account is branded. Mine is not.
We could even meet up. At one point, I said a coffee shop with people around, and she declined that and said, no, we need to meet up in private. So I said no to that, and blocked her again on this phone number.
Yep, email address. Okay.
Again, 10, this is another phone number. She mentions going dark.
10?
Which is reference to me not responding to her. Again, just to highlight that she has been consistently harassing me with me not responding to her for the large majority of these messages. The only time that I was often responding was to try to get the test scheduled. Outside of that, I did not. I had little to no interaction with her. And so at this point, she references here, I will cancel the Rabgen appointment. She had scheduled one, paid the $750 for it. But then in the past, as she had stated, she'd scheduled that she would end up canceling these. So
there she is, pulling that thing up.
On her side of things to say, yes, I'm trying to do this test. But when it came down to it, she always placed stipulations whenever I responded to her. So at this point, when she said I'd spend $750, I did not respond to this and blocked this phone number because I was not taking any of what she was saying seriously. Because every time I would ask, okay, let's do this, she would bring a stipulation on board.
Yep.
Submit 10 over the objection.
11. So again, similar thing. I think this was around the same time. She said she'll tell Rabgen that we don't want the appointment next week. But I couldn't be more steadfast on my decision not to take it earlier than the stipulation. So again, the stipulation is the only way, as she says here, and then she says, anyway, I hate to go to the press, but that was your decision as well, and I respect it.
Rolling. Keep them dogs rolling raw hard.
For real estate. So again, I don't understand why, as clearly there's no relationship here or any interest in me wanting to talk, but yet she was trying to have any type of discussion with me. But again, she says your stipulation is the only way to do the test, and so I ended up blocking her again.
There she is, pushing that baby bump up again.
12, again, this one, she said she wants to do the test. I then said, you want to do the test and no stipulations. She said, you're going to be forced by the court to meet up with me. So the second I found out that she, again, I asked, she'd do no stipulation. She ended up saying you have to meet up with me. And then she said down here, I said, you're willing to meet up in a very public place. You will take the test afterwards. She said, no, it's with a week worth of stipulations and hopefully more. So again, she stated that after she said she wants to take the test, she then confirmed that she was not willing to take the test unless the stipulations were added.
Amendment 12 over the objection.
13. So again, another message from Laura, different number.
I like how he's doing this. I mean, And we watched one last night where this guy was, going off on just rambling about, well, I've got this Instagram account and this Instagram account and this Facebook account, and these are how many people I have, and I have famous people in here, and blah 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 blah. And he goes on for 20 minutes. Like, okay, so what does this have to do with anything? And the judge basically broke it down in 20 seconds. He says, so you have, after his 20 minutes of rambling, he goes, okay, so you have a parody account. You call it a parody account that got removed, and it's tied to another email address, and that account got moved also. And he was like, yes. He's like, okay, you could have just said that. And of course, the attorney is like, well, according to the terms, if you are going to do a parody account, it has to be very clear that it is a parody account. You could, something's as simple as, this is Shizzy Wiznut parody account, and they won't remove you. The only problem is then you run into other issues. They could still remove you, especially if you're doing something that was trying to take down another channel, or it was clearly not parody, that you were trying to mimic every single thing that they were doing. Then in that case, YouTube would take it down. Like if you were just basically created an account called Shizzy Wiznut Parody and then just played my streams, you recorded all my streams and played those as being your own, that right there would get you like banned, like in a heartbeat. They would ban that stuff. They have very strict rules on the terms of use, and that's what he was trying to fight. The way that guy is sitting there was rambling. Eckert has come in here very pointed. This is another email. This is what it says. This is why I feel that it's harassing, and I want to enter it into exhibits. So he's not telling her what's in the email. He's just being very to the point.
I asked her if she'll meet up at the court. The media are present. She said that's not how it goes. We can meet up just us, and I will withdraw the request for sanctions. And then again, she said, would you meet up in a public location?
Maybe.
Cut off. It was in another text message. But she ended up disagreeing or not being willing to meet publicly. She said we had to meet privately, and so then I blocked her on this phone number as well.
On the 13th, no objection.
Okay.
See the irony?
How am I doing on time?
You have about 10 minutes.
That's okay.
I do 10 minutes.
I want to skip now. I want to make sure I get to the ones that I really want to talk about.
Mm-hmm.
Okay, so Exhibit 15. Laura sent me a very alarming message stating that she was going to kill herself if I do not remove it was a video that I posted to my Instagram. So Laura has claimed that my responses online are meant to defame her, but that is not the case. Laura decided to leak this story to The Sun originally, and she leaked it with her anonymously, so she did not place her name out there. But what she did do is she mentioned to them that we had an active court case. So that active court case, she is the one that brought that against me. In that court case, her name was on the court documents. So she ended up then bringing that, figuring out once this was leaked to The Sun, they submitted the story, and then it stated that within that document that there was an active court case with me. People then searched my name and found her name through that. So this email right here, she was basically threatening me to take down my video. In my video, I just stated that this individual was making these claims. I just made a statement of the facts that they were making these claims, and they opened the court case against me. And then from there, I do have a large following. I am a public figure, a celebrity, I suppose. I don't like that word. But I have a large following, and then that audience, I cannot control what they do. But they then went and found that court case in the system and found her name, and then started to talk about her online. And then Laura, I assume, was feeling the pressure from it being online and her name being out there. She then sends me this alarming message, which again I felt was harassing. She threatened to kill herself. I don't think anybody should ever receive a message such as that.
Yep.
All right.
Your Honor, I'm going to continue to object for the same reasons that the other exhibits 2 through 11, actually 2 through 13.
It's a virgin pregnancy.
Again, this is showing that this is harassment by sending an email to him, asking him to take down posts or saying that maybe she not be admitted into evidence.
All right, I'll admit.
Well, and that's one of the reasons why my name doesn't get out there as much. And because a lot of people want to put it down as being like a slang for shitty, but that wasn't what it was supposed to be about. So that tends to like do the same thing. It sucks. Sucks. Yeah, she's moving that baby bump all over the place.
15 over the objection.
Thank you.
Have them up, baby.
Come back to that. Let's see, I just want to make sure if I have some on that time here.
There she goes, rubbing it again. I mean,
I will jump ahead here just to Exhibit 23. So Laura has contacted multiple nonprofits that I work for in attempts to.
I've seen your photography, Heather. It's awesome.
Basically get them to not work with me. So in this email here, she sent this to the Arizona SPC. This was I just spoke actually at this Hope conference. I'm a mental health advocate. And so Laura began to blackmail me and reach out to individuals that she had seen that I interacted with online. So I'd like to admit this as evidence that, again, she was harassing me through reaching out to individuals close to me in attempts to defame me.
And how did you get this? It was sent to you as well?
She copied me on email.
Okay, and when was this sent?
This was sent on August 3rd, 2023.
Okay. Any objection?
Yes, Your Honor, I'm going to object because this appears to be an email that Mr. Eckert was
pretty astute of you there, Mr. Obvious.
Reasoning for why she believed that he shouldn't be a speaker at this conference. Again, this isn't harassment, and it doesn't seem like it was directed toward him. It was directed, although he was CC'd in the email, or he was in the email, it was directed to the Hope conference in relation to whether he should be speaking at this based on what was going on and his credibility.
Yeah.
It would be appropriate to be admitted in this case. This wasn't directed towards him for harassment purposes.
That was.
So this shouldn't be admitted.
All right, I'm going to admit 23 over the objection.
Yeah, it should be. I mean, dude. You know, this is that right there is interfering with it. Love it when she asks to show him she's pregnant. Judge said no.
I would like to now go to Exhibit 26. This email was
all right, let's get past this part.
I don't have.
I'm not sure what that is, but you can.
Again,
More exhibits.
The father of our alleged children should be able to have access to her medical records, especially when it's pertaining to pregnancy.
But it is true that at the beginning, back in May,
Oh, this is where he's questioning him. Okay.
My client isn't even on this email.
Right.
And no interest in wanting to meet up, and she was still sending me these messages after. So this was a threatening email where she was stating.
Got that. Okay.
Meet up, and she was still sending me these messages. I mean, I could try to submit the rest of these, but I think I've run out of time.
All right, thank you.
Good on him.
Yes, Your Honor. You were Laura's real estate agent, is that correct?
I was for a brief period of time, correct.
Okay. And that was earlier this year, is that correct?
Correct.
All right. And back in around May of 2023, you and Laura had become intimate, is that correct?
Correct.
And since then, Laura has made it known to you or has claimed that she's been pregnant, is that correct?
Correct.
And you have, even until this day, you've refused to believe that Laura is pregnant, is that correct?
I would say that's not correct. I mean, I did question, yes, if she was, but I have tried to give her every possible option or ability to prove to me that she's pregnant. She's not allowed me to talk to any of her medical examiners that have administered the quote-unquote ultrasounds that she has done.
Okay, and she isn't required to give you her health information, is that correct?
I personally would say that when she's claiming I'm the father, that the father of her alleged children should be able to have access to her medical records, especially when it's pertaining to pregnancy.
But it is.
Yeah, I'm with him on that. and take part in activities in nature, sunsets, and flower landscapes. The lawyer seems very young. Who thinks she targeted a young lawyer for a reason, or is it just my suspicious mind? No, I think she shopped around, found an attorney that would take the case. And I mean, This guy actually is from what I've been able to tell, has been a pretty solid attorney. He raised the right objections. And also whenever he realized that she was lying to him, he got himself out of that case and signed an affidavit saying, listen, what she's been saying is not correct in this particular matter here, and I can't with conscience, represent her anymore. He was like, gone, done, out, see you, bye. Like, whenever he figured out what was happening, he didn't want any part of whatever scam she was running. So that he could have run with it, but whenever he realized what it was, he was like, I'm out.
It is true that at the beginning, back in maybe May or June, you did not believe that Laura was in fact pregnant. Is that correct?
Yes, I have questions. She's pregnant.
Okay, fine. You have exchanged emails or text messages with Laura indicating that you did want her to get an abortion. Is that correct?
I had stated that if my preference was to not have children with her, but it was ultimately her choice, and I was not going to pressure her.
And those were communications that you had back and forth with Laura in text messages. Is that correct?
Yes, we had interacted via email early on.
Okay. But had you also interacted with her in text messages?
Yes, as evidence I've submitted, I did respond to her early
Yep.
messages.
Now, you agreed to meet with Laura or have Laura come to your house to do a pregnancy test. Is that correct?
That's correct.
Yes.
And Laura did come to your house to do, or go to your house to do a pregnancy test, correct?
Yes.
Yeah, and see, he's right here. Another attorney would be objecting to this, like another, because right now he's trying to prove something that the judge doesn't want to hear about, and usually another attorney would step in and say, I object. I thought we were going to stick to the harassment portion of this, Your Honor. What does this have to do with anything? I mean, I understand where he may be going, but we can both agree that these did happen, that there was conversations early on that these things did happen. But Your Honor, we're not here to prove whether she's pregnant or not, because it goes to show that she's had every opportunity to go get a full test and have the HGC tested, and also do a full workup where they can sit there and do an ultrasound with that is with whenever he's there, and they show him exactly, yes, here is the twins. She would never do any of that. She would never submit to the test that she needed to, and come to find out that she was getting, these, what was HRT or HGT or something like that, injections, which boosts up the levels. And you do this if you are trying to get pregnant through IVF. So whenever they found all this stuff, this is why she's looking at 14 counts of felony. 14 felonies.
That showed that she wasn't pregnant. Is that correct?
And showed that
she peed on a stick.
Okay. And when you all agreed to do that, you were communicating back and forth with Laura, correct? She didn't just show up at your house.
There she goes with her belly. She's moved it up
then
again.
Not only whether she was actually pregnant, but then whether you were the father. Is that correct?
That is correct.
And Laura went out of her way to schedule various paternity tests to show that you were the father. Is that correct?
Yep.
So that I would say she was claiming she scheduled them. She did schedule a few, but then whenever I did not agree to her stipulation, she canceled them.
Okay. So she scheduled a few. Is that correct?
I believe she did, yes.
Okay. And it was her that did the scheduling. Is that correct?
Until I scheduled one, yes, that she and I took recently, which came back little to no fetal DNA present.
Okay. The communication between you and Laura for the scheduling.
And you hear that. You hear that right there. Listen to what he just said. As she's rubbing her belly.
She scheduled them. She did schedule a few, but then whenever I did not agree to her stipulation, she canceled them.
Okay. So she scheduled a few. Is that correct?
I believe she did, yes.
Okay. And it was her that did the scheduling. Is that correct?
Here it comes.
I scheduled one, yes. That
Listen to this very closely, what he says.
and I took recently, which came back little to no fetal DNA present.
as she's sitting here rubbing her belly, he said it came back with little to no fetal DNA present. As she's rubbing her belly, no fetal DNA, no baby.
Okay. The communication between you and Laura for the scheduling, was that through email?
Yes, mostly it was over email at that point, correct.
Some of it was through text messages, is that correct?
I had asked for her to schedule them via text. Yes, I believe that, yes, I mean, as you saw in the exhibits, I had asked for if she would do it without stipulations.
Okay. And so there was communication back and forth between you and Laura, is that correct?
It's very limited overall considering the frequency of the messages she sent, but yes, at certain points I was trying to work this out with her.
Okay. Now, the text messages and emails that you've provided to the court today, those are not all of the text messages from you, and of course, they're not all of the text messages from her. Is that correct?
That's correct.
And same thing with the emails. That's not all the emails.
Yes,
from her.
they did.
Is that correct?
That is correct.
Okay.
I will not be able to submit.
I don't have a question. Now, Laura, you at some point in time stopped responding to Laura, whether it be through text messages or emails. Is that correct?
Yes.
And this
Yes.
was also around the time when Laura was trying to schedule the paternity test. Is that correct?
I stopped responding, and then she started to state she wanted to schedule a test. Just she was claiming she wanted to, but she would never, whenever it came down to me wanting to schedule it with no stipulations. So I stopped responding at a certain point when I realized that she would always keep adding the stipulations in. From that point forward, she was making claims she wanted to schedule them. It didn't mean anything. She'd already proven that she had no interest in actually following through.
Was there a time that you're aware of that Laura hired an attorney to help schedule the paternity testing?
I had one of her attorneys at one point, and they had shown me the ultrasound that I had admitted here, and I asked for them to subpoena the records from that ultrasound. She would not provide it, and then stated that I asked her if she would schedule without stipulations, and the lawyer told me she would not.
Okay. Laura paid for you.
And that is such a very good point, Derek. If the genders were reversed, a woman had been called by 13 phone numbers from the same guy and emails and texts, and the man was told no. This would be a no-brainer. Absolutely, Ronnie. Ronnie, oh my gosh, Jizzy, when is this lawyer going to get up and say, Judge, it's time for me to go. My client lied. Can an attorney do that? Yes, they can. Usually they will, they'll be a little more subtle about it, in a sense. Usually whenever something like that happens, instead of raising a big stink about it, they'll ask for a recess. They'll ask to speak to the judge in their chambers, so this way it's off the record. And because you don't know what the lie could possibly be. Also, it could be, attorney-client privilege. But if you find out that and you have to inform the court, I mean, that is the proper thing to do. Put the bricks down. Step away from the large cement objects, unless it's a plaster remake of David. Step away. But yeah, this is where you say you do have to fight for your client vigorously, even if they are lying and they are lying, and try to get away from them, because I think there's certain rules behind that, but I couldn't tell you what they are.
You to have or to do some sort of blood test to determine to do your part of the paternity testing. Is that correct?
As I referenced in my exhibits, she did make a payment, and then when I would not do it without the stipulations, she canceled.
She canceled, or you canceled?
Canceled.
She canceled.
Somebody canceled my portion. It was not me. It was I. They called in and tried to cancel my portion, in which case I found that out, and that's what led to me scheduling it and then going online to make a statement so everyone knew that I was trying to do this paternity test. I did not cancel it, though. Absolutely not. Somebody called in and canceled it for me because our names were under the same test.
You're stating that somebody canceled a paternity test on your behalf, and it wasn't you, and you didn't authorize that?
That is correct.
That is correct.
Now, you and Laura have an active family court case together. Is that correct?
That is correct.
And it was Laura that filed that case against you. Is that correct?
That's correct.
And this family court case is in regard to paternity. Is that correct?
In regard to a parenting plan, she filed for a parenting plan.
Okay.
The children that have not been proven.
All right. And you're not represented by an attorney. Is that correct in that family court case?
That is correct.
Okay. And is it your understanding that she, at least at the time, wasn't represented by an attorney in that case?
I understand the purpose of that question, but I don't. So I've spoken with lawyers. I believe that she filed in that case, though, as representing herself.
Okay. And the court ordered that you guys meet in
Yeah.
person. Is that correct?
For an early resolution conference virtually, but not to meet in person. That was never sent to me, although she claims that the court mandated that.
To resolve different issues prior to that conference. Is that correct?
The court did not mandate that. I never was told by the court. I was told to show up to an early resolution conference. She said that we were supposed to, if able to. Apparently, the court asked that individuals try to resolve all matters, but I had no interest in doing that because I did not trust her if we were to meet up one-on-one, which she would accuse me of.
Okay.
Exactly.
But she emailed you or texted you in regard to trying to resolve those issues before showing up to the early resolution conference. Is that correct?
Claim that we needed to meet up to discuss matters. What specifically I was not sure of.
Now, you have accused Laura multiple times of lying that she is pregnant. Is that correct?
That's correct.
And you've done that online. Is that correct?
I believe in the video, again, I never once mentioned her name. I believe I may have said I questioned whether or not she was pregnant.
Okay, so you insinuated that she was lying. Is that correct?
I believe she is lying, yes.
And the different media outlets that have you spoken to media outlets about this?
I early on provided statements to a couple of outlets to state that I did not believe that I was a father, and that I was hoping to do a prenatal paternity test in order to prove whether or not I in fact was.
Okay. And up until recently, you hadn't done a paternity test. Is that correct?
Yes, but that was because of Ms. Owens was not willing to do one as I asked her to as far back as 4 months ago.
Okay, so you're blaming Ms. Owens.
4 months.
Paternity test. Is that correct? Correct. And that's
So
why
she's
she wouldn't do
supposedly
the test.
4 or 5 months pregnant here?
She would not do it unless I were to date her. Those were her stipulations.
Now, you indicated that you spoke to the media about this, and they published those statements online. Is that correct?
There were a few outlets, yes, that published my response. Yes.
And the results of the paternity test are not resolved. Is that correct?
I was told that little to no fetal DNA was present on the first sample and that she needed to another sample.
Oh.
So the results are not in yet. Is that correct?
Yes, I suppose that is correct.
Now, you indicated that Laura had blocked you several times. Or, sorry, I apologize. You had indicated during your testimony that you had blocked Laura several times in various from various numbers. Is that correct?
Yes.
I think it's larger than large nuts.
Okay. But you were in communication with
Big,
Laura
huge nuts.
this entire time since May. Is that correct?
I would not say that's correct. I was not in communication the entire time. If I were to be able to show all the exhibits, I'd probably responded to maybe 5% of what she was saying to me.
Okay.
Hey, Wicker.
Look at Exhibit 4.
Oh, I'm sorry. That says Wickedest Car. Well, thank you, Wickedest Car, for coming by. You are always welcome here, and we are gathering members and super chats, and just thankful for every single one of you guys being here, and welcome. This is a great place to be, and we are pretty chill over here. Amazing enough. Sometimes I get a little antsy, and I get a bee in my bonnet, but generally this is I'm pretty chill. But I'm glad you're here. Definitely, thank you. Tug's good people.
Exhibit 4. You had indicated that this was a text message from Laura to you. Is that correct? Yes. Okay. And you had responded to Laura in this particular text message. Is that correct?
Correct.
Okay. Is that the same thing with Exhibit 12 and Exhibit 13? You had responded to Laura after she messaged you?
Mm-hmm.
If there's a text bubble, as I'm trying to look here for the sake of second time, if there's a text bubble, then
That's good.
in those messages.
Okay. And in all of these text messages that you submitted to the court, did you ever one time tell Laura to stop texting you?
multiple times I asked her to stop communicating with me.
Okay, I'm asking in the exhibits you submitted to the court and in your testimony, you not one time ever said that Laura stopped texting me or stopped communicating with me, did you?
I'd have to look back at the exhibits that I directly submitted, but I've asked multiple times for her to cease communication. I know you're asking for me specifically if I stated this in these text messages, but I can absolutely confirm I've asked her multiple times to start responding to me. And I have evidence to prove that, maybe not on these text messages alone, but again, I have 500 exhibits I could have been submitted.
And isn't it true that you indicated Laura threatened to go to the media regarding this, correct? You had indicated that Laura had spoken to you via email or text message that she was willing to go to the media to discuss what was going on between you and her. Is that correct?
No.
Yeah, she said she was going to go to the media, yes.
And didn't you email or text Laura indicating, go ahead, essentially, go ahead, you can talk to the media?
I believe I did state that at one point, because my reasoning for that was because I knew she was trying to threaten me and scare me by going to the media, and I did not want to give her the joy or whatever you want to call it of knowing that she was affecting me. So I just stated, sure, if you want to go to the media, go to the media. But I was not giving her permit. I guess I wasn't agreeing to it. I just knew it was inevitable. She was threatening me.
So you consented to it?
No.
I wouldn't say I consented to it. I wanted to resolve this privately, very, very early on, multiple times. And as I sent some of the exhibits show, I was trying to. She had threatened to go to the media multiple times. And at that point, after she had threatened me multiple times, I stated, go ahead, just simply because I knew that she was going to continue to threaten me and she would eventually go public.
Mm-hmm.
You have an
Yeah.
opportunity to provide rebuttal testimony if you want to, based on what he's asked you. If you have anything else you want to help clarify.
Yeah.
Thank you.
Again, I think what he's trying or what he's attempting to show is that there was continuous communication throughout. And I believe, again, this is a matter of frequency, my messages versus hers. I was continuously trying to solve this matter, and a few times that I did reach out, I was trying to come to a conclusion. Again, had I actually been the father and the prenatal paternity test was done 4 months ago, I was willing to take the test back then and willing to then move forward from that point. But this individual, Ms. Owens, never had any interest in settling this matter. This again, as I had referenced in our prior cases, this individual, I believe, again, this is just my opinion, but, harasses individuals into dating her. And when they do not want to, then she starts to say that she's not willing to take a test, or at one point it was, I'll take Plan B or the abortion pills if you agree to date. So there's always stipulations around that. But the few times where I did respond to her, it was from me trying to get a prenatal paternity test on the books, because I was wanting to be able to prove that I was not, in fact, the father. Through all of this, I just want to make this statement. Ms. Owens has not been able to prove that she is 5 months pregnant with twins. The HCG test, you can manipulate HCG levels. These sonograms don't auto-report with them either. And so no doctor has ever stood behind these tests and been willing to state that she is, in fact, pregnant with 5 months pregnant with twins. And so
No, I'm not judge right now. This sounds like a closing argument as opposed to testimony.
Does it meet the pub test? That's good.
So again, the whole thing for me is I've been trying to quash this. I've been trying to come to a solution. I never wanted this to be public. I never wanted this to get out there and be such a big deal, but this individual did and made sure that it got out. I would just, again, I would like the order of protection and injunction against harassment. I would like that, because this individual is an aggressor, and if she will not continue to come after me, or she will continue to come after me unless I cut off communication. And so this is whether or not I responded, it's the sheer frequency of unwanted messages that she sent me.
Tell me what that is. Tell me what you believe.
Tell me what that is. One message after I've told her not to contact me is one too many. After I've told her, do not contact me anymore. One message. That is more. More than I have asked. She still won't stop. How many men's faces can you put on a rubber baby belly? Sounds like a challenge for a chat GPT, Shizzy. Might be a funny one. Ooh, I've got some bad ones. I can't play those. I've got some bad ones. But this is where we're going to call it a night. I've been going for 2.5 hours. I appreciate every single one of you. I'm going to send you guys over. I think, and I could be wrong. I think there might be somebody streaming right about now. I think it might be MG. I think that he is probably watching a little bit of crazy, as he always does. And I'm going to send you guys over there. Thank you guys so much for coming by tonight. And thank you, Tug and Tug Raiders. And thank you, new members. All 15 of you guys, thank you for the super chats. It has been my pleasure to host this crazy one tonight. I do have, and of course, if you were here early, you would have seen the document that I read, which if you haven't seen it, go back and watch, because right there at the beginning is where it's a little bit crazy. If you know anything about what's going on with Ducey and Cayo. Ooh. And then of course, tomorrow I've got another thing that I'm going to bring up, and I hope it's good. I was going to work on it, but because I wanted to be with the wonderful Rosalind Duke tonight. It was earlier this evening, and she's always fun to hang out with. And we talked about music and AI videos and creation and all kinds of stuff. So I think you'll enjoy that. Go check it out. And most definitely we'll see you on the flip side of things, and appreciate every single one of you. Thank you guys so much. And just remember,
Breaking news or whatever. They're on another one. Gang, gang. Yeah. Gang, gang, emergency Zoom film at 11. Same 5 goons, same deranged obsession. This changes everything. Bro, it's page 47 of emotion they skin while half watching Yellowstone. Gang, gang. Squinting at 8-point font like detectives. Zoom so far and the pixels are screaming for mercy. Look at this, timestamp 20, 22, my God. But they're yelling it like they just cracked Watergate. High five. Mike's been muted for 20 minutes, still barking. Circular logic, so a lot of time that's impressive. Trust the plan, this is massive. Nah, fam, it's boilerplate and it's mid at best. Gang, gang. Self-appointed outrage, swap patting each other like they personally ended corruption. Gang. Dropping bombshell tea that's been sitting in pieces since breakfast. Gang, gang. Moral high ground, speed run, they'll flip the script the second it's convenient. Gang. Same PowerPoint presentation, new day, same brain dead narration. Gang, gang. We're not obsessed, we're just passionate. 3-hour living yesterday's hoodie, passion in my ass. Why is he even breathing right now? Says the guy refreshing notifications every 14 seconds. Gang, gang. Playing lawyer on God mode, reading comprehension. Stuck in elementary, confidence in the stratosphere. Case dismissed. They're screaming to the void. Motion still pending, but go off, I guess. Disagree? Obviously a paid chill. Actually read the filing, deep state plan. Laugh at them, you're clearly compromised too. Exist in the same zip code. Suspicious behavior, notify the group chat. Gang, 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 gang. Tighter circle, smaller brain. Gang, gang. Echo chamber finally running out of oxygen. Gang, gang. Yeah. Gang, gang, acting the actual judge like it's group chat. Replay all meltdowns, labeled just asking questions. Got warned by the core once, that was a suggestion. Still yeeted the same screed like it's strictly trash talk. Gang, gang, we're above all this drama. While screenshotting, they on meltdown for content. Preaching peace and love while actively baiting bears. And fake shock when the bear finally bites back. How could this happen? Gang, gang, synchronized tantrum hours. 5 tabs open, all the same screenshot. Different zoom levels, gang, gang. Premature victory lap over legal language, still can't pause. Gang, gang, standing 10 toes on business until tomorrow's finally send them scrambling again. Gang, gang. Hype the claim to the moon, then ghost the chat when it ages like milk. Gang, gang. Gang, 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 gang. Gang, gang. Refresh. Gang, gang. Gang, 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 gang. See y'all same time tomorrow. Gang, gang. Don't be late.
Peace, y'all.